All right. Well, hello, everyone. I hope you can see me okay over there out in the web. My name is Sean Scott. I'm going to be your presenter this evening. We have an interesting thing that we've never done before, which is a webinar where we're hoping to do one of our normal seminars kind of in a virtual way. Joining me tonight in my conference room is some people from Karen Carley's or Karen Truman's support group. They're going to be asking some questions live. They're kind of like our live studio audience, so to speak. And then we have you guys out there on the web, which can ask questions as well. You'll see in the webinar program off to your right that there is a question and answer kind of chat window that you can type your questions in. And my assistant, Cindy, will process your questions and ask them for you so that you don't actually have to ask them live over the webinar. So just feel free to type your questions in at any time, and we'll try to incorporate them into the presentation as we go through it tonight. We hope to be on for about an hour. We have a lot to talk about tonight. We're going to start with the first question, basically, and that is are any of you guys getting older?
Yes.
Yeah. So who's getting older? Right? Yay, good. I hope everybody answers in the affirmative there, because you have to say yes to that question. I just recently found out that the person who I frequently misquote this saying to, I didn't know actually there was a person that had said it, and that is that if you're not getting older, you're dead. Okay, and that person who originally said that, or at least is attributed to, is the rock and roller Tom Petty. So I find it that it's a metaphor for life. Every day is is what life's all about, that we live another day. However, as we age, we start to run into problems that we didn't have when we were younger. When we were 20, we thought we were going to live forever. And now when we're getting older, we're starting to run into some problems. Now, what we find there's three major problems that we run into in my particular practice in elder law. The first problem is that of incapacity. In other words, I can't manage my own affairs. Who's going to manage them for me? Who's going to step in and have the ability to manage those things on my behalf? I'm going to talk a little bit about that this evening. We're also going to talk a little bit about mortality. Again, as you age, the prospect of mortality starts to peek around the corner. When we were 20, we were going to live forever. But now that we're getting a little bit older, maybe that's not going to be the case. And the issue of mortality does weave its way through the whole issue of Medicaid planning and what I do in my practice. So that's something we're going to discuss a little bit tonight as well. And lastly, is this issue of care. When we get older, there is a possibility that we may not be able to take care of ourselves. And if we can't take care of ourselves, and or our loved ones can't take care of us in our own home, what happens in that situation? Who's going to take care of us? Oftentimes in our modern day, in our modern era, we turn outside the home to either an assisted living facility or a nursing home to provide that care. Well, the problem with that is that in today's economy, in today's environment, that particular type of care is very, very expensive. Now, I don't know if any of you guys have had any particular experience with that, but in our local community here on the west coast of Florida, it's running about $10,500 a month just for the room and board portion of the stay in a nursing home. It's kind of shocking, actually. I just saw a bill from a local facility this week, and it seems like that cost is going up over time every year. So $10,500 a month creates a pretty big problem. Now, when we talk about these three problems, there's three solutions that we're going to go over tonight. I like the three thing, the Trinity, always nice, things come in threes. The first thing is that we need to have a good, durable power of attorney to address that issue of incapacity. The second thing is we want to update our estate plan, especially in the situation where we have a husband and wife going into long-term care or aging, where one of them has the prospect perhaps of going into long-term care. For example, if you have a diagnosis of Alzheimer's or some other debilitating disease, you're going to want to have an updated estate plan in a husband and wife situation. Very, very, very critical. And lastly, we need to discuss the issue of Medicaid. Medicaid is a very, very big component of your planning situation. As you grow older and as you face the prospect of long-term care, you need to understand how Medicaid works. So that's going to be a lot of time where we spend tonight. All right, so let's talk about incapacity first. When we talk about incapacity, one of the biggest things and one of my biggest hot button issues is the fact that you need to have a good, durable power of attorney in place. Now, a power of attorney is no more than appointing a co-pilot to act on your behalf. This co-pilot is somebody that can control the airplane, can metaphorically can control your affairs in the event that you cannot. Unfortunately, especially in Florida, most of the power of attorneys that I review are not effective in order to do what they purport to do. In other words, they're fundamentally flawed. They're fundamentally flawed because the Florida legislature did us a favor, and I'll put that in quotation marks, by once upon a time putting a sample power of attorney into the Florida statutes. And when they did that, lawyers would copy that right out of the statutes and make that their form for a power of attorney. That creates a lot of problems for you because that sample form isn't good enough. It's missing 5 components, and I call those my big 5. Now, the first thing on the big 5 is that we need to have the power to create a trust inside your durable power of attorney. If you don't have that power in there, it's fundamentally flawed and needs to be redone. Okay? Why? You'll see in a little bit that the power to create a trust is critical in many cases in order to obtain Medicaid benefits. If you don't have that authority contained within that piece of paper, you can't create the trust and you're off to the courthouse to get a guardianship, which can take several weeks, if not months, to get completed. All during that period of time, you're going to be disqualified for Medicaid benefits. And at $10,500 a month, that's a pretty expensive process. Not the least of which the attorneys and the court costs and that, but just being ineligible for Medicaid while that guardianship is winding its way through the court can create a very expensive situation for you. So having a good durable power of attorney with that power to create a trust can help you avoid that guardianship. Second of my big 5, and that is the power to manage IRAs. IRAs, individual retirement accounts. Many of you may have an individual retirement account, or you may be taking care of somebody who does have an individual retirement account. If you have this situation, most power of attorneys don't actually specifically allow the agent or the co-pilot to act and to manage an IRA. If that authority is not contained within the power of attorney, then you can't manage the IRA. It's that simple. Okay. Managing the IRA is going to be critical to Medicaid eligibility in order to access it, in order to change its characteristics, in order to protect and preserve it. If we don't have that power inside the durable power of attorney, you're going to be in trouble again and you're going to be kept from being eligible, and it's off to guardianship court again and to do that whole situation just to get the authority so that the bank will listen to somebody so that we can manage and protect that power of attorney. Okay. Third thing, power to make gifts to the agent. The agent is the person who's acting on your behalf. He is the or she is the durable power of attorney that is your co-pilot. In many situations, the power of attorney does not have the authority to make a gift to himself or herself. Most don't. That's been held in common law that if you try to enrich yourself or self-deal, use this power of attorney to make a transfer to yourself, for example, that's not allowable, unless the power of attorney specifically says you can do that. This comes into play again in Medicaid planning, in that I may have a husband and wife, for example, who has a home, and we want to move that home into just one person's name. And I want to move it, say, into the wife's name, who's still competent. The husband's incompetent, and I need to sign on his behalf by using the durable power of attorney, or I should say the wife needs to sign on his behalf. If she doesn't have that power to make a gift to the agent, to herself, then she's not going to be able to sign the deed, and she's not going to be able to move the house over to herself. Interesting, huh? Okay, didn't know that, did you? Good, at least we're learning something tonight. All right, lastly, or actually not lastly, but next to last, is the power to manage the homestead. The homestead in Florida specifically has all kinds of interesting characteristics, and it's kind of a sacred asset. And because of these characteristics and its sacredness, the law has evolved to treat the home of the individual different than any other piece of real estate. Because of that, I want to see the power of attorney have language in it specifically addressing dealing with the homestead. Okay? If it doesn't have that, we may not be able to extinguish the spouse's right in that home. Why would we want to do that? Well, if we want to sell it later on down the road, I want to be able to extinguish his right. If I want to transfer it upon the death of the first spouse to die, the healthy spouse, I want to have him or her, the person in the nursing home on Medicaid, no longer having any rights in that home. And the only way I can do that, perhaps, is with this power of attorney, with specific authority to deal with the homestead of the individual. So that's a very, very big deal, especially in Florida. All right, lastly, I want to have a backup agent. Always have a backup to your backup. You're appointing a co-pilot, but I think it's a very good idea to have somebody else standing behind your co-pilot, so to speak, that if that person can't serve, that somebody will step up and fill their shoes on your behalf. Okay. It's very important in a husband and wife situation. We may be getting older. We may be reaching a point where we're just able to manage our own affairs, and we're going to manage the affairs of our spouse as well. But what happens if something happens to you, which is likely as you age, or it's possible at least? I need to have somebody that's going to back you up if you're backing up your spouse. Son or daughter, perhaps, is oftentimes a good choice. Okay. All right. So we talked about estate planning or mortality as being an issue. Estate planning is very simple. It really deals with three concepts, very straightforward. Most of the time, we kind of take this for granted, but can be very, very important in a spousal situation. When a spousal situation, I mean by one person going into the nursing home and the spouse not going into the nursing home, one of the most common mistakes that I see made in Medicaid qualification is the failure to address the estate plan of the, I'll say, quote unquote, the healthy spouse. We're always focused on getting the one spouse eligible for Medicaid, and all our focus is on getting the assets positioned correctly, the income positioned correctly, making sure we pick the right nursing home, transitioning it into the nursing home, all that emotional side of things. There's a lot on our plate. So what falls off oftentimes is the estate plan of the healthier spouse. What happens in a husband and wife situation is you usually go into this process with what I call I love you wills. And that I love you will is a reciprocal will that says that in the event that I die, honey, that you get my estate, and vice versa. If you die, you leave everything to me. That doesn't work so well in a situation where one of you's on Medicaid. If one of you's on Medicaid and the healthier of the two of you dies and leaves all of your assets to the person who's in the nursing home, incapacitated and on Medicaid, you're going to create a problem of management, who's going to manage those assets, and you're also going to destroy their eligibility for Medicaid benefits. So not only do you die, which is a bad thing, but now your spouse that you leave behind is now ineligible and disqualified for Medicaid benefits because you died. That's a big deal. And it's very common omission in these circumstances is to not address that. Okay, so you guys learned something else today. That's good. Everybody's being so quiet. All right. Remember, I said you can't ask questions. Okay, so very good. So planning the estate, very straightforward. There's three things. We want to know who's in charge. So we need to appoint somebody to be in charge. If your spouse is the person who's supposed to be in charge and he or she is in the nursing home, it's not a real good idea to appoint them in that capacity, is it? So we need to change that. We also need to know is where is it going? It would be your estate plan. Okay, your estate, I should say, the stuff that you own when you die. Where is it going? Who is it going to, in other words? Should not go to the person who's in the nursing home. In other words, who's getting it there? Lastly, who's in charge? Who's moving the assets over to the spouse? Okay.
Wouldn't there be some
away from the spouse? Excuse me, I made a mistake.
Some other thoughts that Medicaid could then come in to get the house too? I mean, can they take that over? Is that another?
Not the question is that in Florida, is the house going to be at risk when the healthy spouse dies? And it's a really good question. Many people think that the house is only protected because there is a spouse in the picture. But the rule is actually that the house continues to be protected even if the spouse dies. So the person in the nursing home can still own the house. There's some problems with that, obviously, maintaining the home, paying for the cost and the upkeep of that home, not being used by this person who's in the nursing home. So there are some practical issues there. But the house is not going to be lost just because the healthy spouse dies first. Okay. What happens if you're single and you have nobody? Well, if you don't have any kids, okay, you don't have any cousins, and you don't have any second cousins, okay. What do you want to do with your stuff when you die? Do you have any? I mean, do you have a desire? Okay, so you're gonna give it to Karen. Okay, that's a good idea. Yeah, I understand. Yeah, I did your estate plan. I know this. So that's fine. In that situation, we have to be very careful that if you're on Medicaid, we have to make sure that your assets, are going to be protected, which we'll talk about in a moment, but that those assets also pass to that person without the ability for Medicaid to put a lien against it. And that's it's an advanced course question, but basically we use some estate planning techniques in order to avoid Medicaid's ability to assert a lien against your assets, okay, including your home, which is probably, if you're single and on Medicaid, really the only asset that you probably have in your ownership at that point in time. So if you're going to leave your home to Karen, for example, here, who is not a relative of yours, who does not enjoy the protection of Florida's Constitution that says that your heirs get the house without any creditor's claims, you're not a protected class. So therefore, if you were on Medicaid and it was going to Karen at your death, Medicaid could assert a lien against your estate and take the home, unless I do something about that, okay? And what we're going to do is we're going to change the ownership on that home so that it can pass to her without Medicaid being able to assert a lien against it.
I wonder if you could immediately upon my death be able to sell it.
Well, if I sold it upon your death, that money would go into your estate. Medicaid has a lien against your estate for the care that they've paid for on your behalf while you were in the nursing home, and they will take that money from your estate. Okay, don't want that. Well, I'm just telling you what the reality is, and that's what happens if you don't do something. But if you take some action, you can fix that problem and make sure that Karen does receive that home when you pass by, how should I say, managing that asset in a way that Medicaid cannot assert a lien against it through proper estate planning. How would we do that specifically? Probably would change the title on the deed. We would, or the title or the ownership on the deed, to put Karen out there to receive that property when you died immediately by reason of the deed and what the deed said. And we use something called an enhanced life estate deed in order to accomplish that. By using that enhanced life estate deed, I can create an ownership interest in Karen, which doesn't create a penalty for Medicaid qualification, but upon your death would make that house immediately go to her, and Medicaid would not be able to assert a lien against the home. And it's not happening for another 20 years. I understand. So yes.
Is that also true if the house is deeded into a trust?
If the house is deeded into a trust, it would also avoid Medicaid's lien in that situation as well. Yep. Okay, there's several different ways of accomplishing the end result of avoiding Medicaid's lien. That would be another way of doing it, okay, by using a trust. Very good. Excellent.
Do you think the law will change in the near future?
Do I think the law will change in the near future on that? Probably not. Okay. I don't see. I think there'd be a hue and cry on that particular issue. We've been trying to protect the home historically under Medicaid since its inception. In some states, in many states, I should say, the house is an asset that's subject to a lien, and it requires planning. One way or another, we need to protect that house, and we're going to do that. Thank goodness in Florida, it's most of the time already protected, except under some rare circumstances like yours, where you don't have an heir who's a blood relative of yours. If you were giving it to Karen or to a charity or something along those lines, exactly. Anybody else other than your family, you stand to have Medicaid lose it. Yeah.
I know.
Still might. Very good. Very good. All right. So that's planning the estate. Any other questions on that? Good. Super. Let's move on to really the core topic of tonight's discussion. That's Medicaid. Medicaid's a really big deal. What we're going to go over today is how Medicaid is used to pay for, or tonight. I usually do these presentations in the daytime, so it's hard for me to say tonight. How it's used to pay for the nursing home. How is Medicaid used in this circumstance, and why do we have to turn to Medicaid at all? And why do we even have to have a discussion about this issue called Medicaid? We're also going to talk about the eligibility requirements. If we're going to be qualified for Medicaid, you need to know how to become eligible, and you need to know what those requirements are. Lastly, next, I should say, is one of those requirements is the income of the individual. The other one is the assets that the couple has or the individual has. And lastly, we're going to talk a little bit about gifts and why gifts are so important to understand the concept of gifts and why they may not be a good idea. All right, so why do we have to talk about Medicaid at all? Well, interestingly enough, back in 1968, there was an issue. And this issue is that we were aging as a country. And President Johnson had came upon the scene, and he thought that maybe government would have a better or a bigger role in the healthcare of the United States citizens. And so he tried to push through something called the Grand or Great Society. The Great Society had a much bigger role of government in our lives. Now, there's big political and philosophical discussion as to whether that's a good idea or not. At the time, he was unable to get this healthcare initiative through Congress. It was shot down, basically, but he was able to get some things in place. Basically, he was able to get healthcare for the old, which is Medicare, and he was able to get healthcare for the poor, which was known as Medicaid. Now, we have to talk about Medicaid today because of Medicare's failure to adequately cover the cost of care for nursing home care. It doesn't adequately cover it. It pays for up to 100 days of nursing home care. At the end of 100 days, Medicare with an R will terminate coverage. So it's not going to be a solution that you can depend on to take care of the problem for a long term. Also, if you're not going through a hospital first and have a qualifying stay, Medicare is not going to cover you. And in many cases, especially when we're dealing with Alzheimer's, the person doesn't go through the hospital and go into the nursing home. He won't go that route. He'll go directly to the nursing home and therefore not be able to trigger any Medicare coverage. So Medicare is really not the solution for us. So we turn to Medicaid basically for two reasons. And one thing you see up on your screen is there's a basic inequality created because of this lack of coverage under Medicare. And that basic inequality comes down to which disease you get. You see, if you're lucky enough to get cancer, that disease process will not bankrupt you because Medicare with an R is going to pay for the cost of that care. It's going to pay for your chemotherapy, your surgery, your oncologist, all of your treatments. And are you going to be wiped out financially because of that disease? No, Medicare is going to step up and pay for the cost of that care. If you're unlucky enough to pull the Alzheimer's card, then you have a situation where that disease process will bankrupt you unless you can figure out a way to pay for the cost of treating that disease. And unfortunately, the treatment of that disease is managing that person, managing their needs, and oftentimes in a nursing home at $10,500 a month. That disease process will bankrupt you. And that's why we need to turn to Medicaid, because Medicaid will supply us an answer for that. Unfortunately, this basic inequality exists where the Medicare doesn't pay for that care, that we have to turn to Medicaid. In some ways, I wish I didn't have to talk to you about Medicaid at all. I just wish there was coverage under Medicare for it, like we would kind of assume there should be. But the reality and the truth is that there isn't adequate coverage under Medicare for this particular problem. The other thing that we want to talk about is fundamental fairness. Fundamental fairness. Is there any reason why, because of you getting the wrong disease, you should be bankrupted? You should be wiped out financially. Does that make any sense? Not at all. So for these two reasons, basic inequality and fundamental fairness, we need to use Medicaid in order to fill the gap created by Medicare. Now, I said 1968 was a big year. That's when Johnson came in, and when Johnson, his effort to get universal health care failed, but he managed to get health care for the old, which was Medicare, and he was able to get health care for the poor, which is Medicaid. Unfortunately, they kind of sandwiched coverage for nursing home care into Medicaid as opposed to Medicare. Made sense at the time. Back in 1968, if you looked at what a nursing home was, it wasn't the same thing that it is today. It was the old folks' home, and because of the advance and the failure of medical science to advance enough, you really didn't live long enough to stay there. So, and you definitely weren't living long enough. True, correct? You weren't living long enough to run into diseases like Alzheimer's disease that we have now in 2013. So 1968, a big day, big year, I should say. We saw Medicaid come onto the field, so to speak. It was originally created for the poor to keep them from literally dying in the street. But then along comes 1988. And what 1988 does is President Reagan is president. President Reagan and the Democratic Congress get together. They actually work together. I know that's kind of strange under today's political situation, but they actually work together to solve a problem. And the problem was that we as a country were getting much older. And since we were getting older, we were running, and our medical science had advanced to a point where it was keeping us older longer. We were becoming, or on the verge of becoming, a nation of poor old people because of seniors falling on the sword of the nursing home, so to speak, and exhausting all of their assets on the cost of care in the nursing home. We would turn in, or could very easily turn into, a nation of poor old people. So President Reagan and Congress got their heads together, and they worked out a solution, or at least some sort of way to fix this problem in some way. Now, as in many things in government, it wasn't the perfect solution, but it was a solution. They probably, again, in retrospect, should have maybe made a component of Medicare, like a Medicare Part N for nursing home care, but they didn't do that. Okay. Instead, they reached down into Medicaid and changed the eligibility requirements for Medicaid to embrace a larger segment of the population. And that larger segment of the population was seniors, aging seniors in our country, to keep them from falling into poverty because of the cost of nursing home care. That particular legislation was the Medicare and Medicaid Catastrophic Coverage Act of 1988. It was really the beginning of what I would call a true elder law practice in this country. At that point in time, when we saw the opening up of Medicaid to more affluent seniors, where you didn't have to be poor any longer, we saw this as a kind of a watershed moment. And from that point in time, which was very easy to qualify for Medicaid in 1988, it has gotten steadily more and more difficult to qualify almost every year. It seems like here we're going to give this to you, and now we're going to take it away in increments. Very interesting. So in my practice in the last 23 years, I've seen Medicaid go from very, very, I guess you could use the word generous, very easy to qualify for, to now in 2013, it's very difficult to qualify for, with many, many catches and gotchas to basically keep you from accessing the system. Interesting. So they give with one hand in 1988 and took with the other hand every year since. That is what it is. You just need to be aware of that kind of environment that you're working in. Things have gotten much more difficult over time. All right. Medicaid eligibility, very important. If you're going to use Medicaid to pay for the cost of care in the nursing home, which is what it's designed to do, it will pay for the cost of care. There's no limitation on how long you can use Medicaid. It's not limited to 100 days. For as long as you need to be in the nursing home, Medicaid will pay for the cost of that stay, in large part. Okay, there are some exceptions. I want to talk about that in a minute when we get to the issue of income. But in order to be eligible for Medicaid, there's some things you need to know about. First of all, you have to be sick enough to qualify. If you're not sick enough to be in the nursing home, Medicaid's not going to pay for you to be there. That's pretty self-explanatory, I guess, when you think about it. Medicaid is not going to pay for a healthy person to reside inside of a nursing home. So there's an initial evaluation and inquiry as to how sick the applicant is. Do they meet a level of care to be in the nursing home? In most of our cases, we find that that is pretty much a foregone conclusion. By the time that you make a decision to place in a nursing home, it's usually well past the point where that person would be sick enough to be eligible for that care. Okay, so illness, it is an issue, but it's one that we don't see as being really a bar to accessing Medicaid. Next is the age of the individual. Back in 1988, when they changed these eligibility requirements and kind of opened up the program, what they did is they wanted to focus the changes on a discrete segment of our population, and that was, let's call the old. And they defined old as 65 years of age or older. That's the rule. In order to be eligible for Medicaid to pay for the cost of care in the nursing home, you have to be 65 years of age or older. If you are less than 65, you may be able to use an exception to the rule, which is that you're disabled. Okay, that you're not able to perform gainful activity according to Social Security's definition. If you meet that definition, then regardless of what your age, you can pass this second requirement and be eligible for Medicaid benefits. The third test to determine eligibility is an inquiry into the finances of that particular person, and sometimes the finances of that person and the spouse as well. In Florida, we look at two things to determine your eligibility for Medicaid benefits. We look at what you get, which are called your assets, and we look at what you get, which is your income. Both of those financial tests have to be passed in order to be able to qualify for Medicaid benefits. What you get, your income and what you got, your assets. Let's deal first with the issue of income. Income is a kind of a mystery on how you define it sometimes. It's actually very simple. I'm not looking at whether it's taxable income or not. I'm looking at whether it comes in. If it comes in under Medicaid rules, it's considered income. That means your Social Security is counted. That means your disability check is counted. May not be taxed, don't care. Your pension is counted. Your interest from your annuities are counted. Your bank accounts are counted. All of those things are considered income for purposes of determining your eligibility for Medicaid benefits. Medicaid sets a limit at how much income that you can have. It's known as the income cap. Medicaid sets this limit in Florida in 2013, kind of a footnote here, it's indexed every year and it will change to a different number in January. But in Florida in 2013, Medicaid sets that limit at $2,130 of gross income per month. $2,130 of gross income per month. The gross number is important here, by the way. Most of you guys will deal with a net income. It's what you put in your checkbook every month. That's not the type of income I'm talking about. I'm talking about the amount that you get before they take out whatever they're taking out. And those of you that are on Social Security, you have to add back in, for example, the Medicare Part B premium and gross that back up. I had a client this morning who was right at the line, $1,997 of income per month. She was telling me that's what they put in the checkbook every month. I didn't want that number. I needed the number for what the gross number for the pension was and what the gross number for Social Security was. Social Security, I already knew there was a Part B premium. I could add that back in, but I didn't know if the pension was taking out anything for, let's say, a Medicare supplement or taxes, exactly. So I need to know what the gross number is. In that case, when they're so close to what we call that income cap or that line, it was very important to understand the difference between gross versus net. Another big distinction regarding income is that we're only looking at the income of the Medicaid applicant. Okay, you don't add the income of the applicant and the spouse together. Understand that? I know it's simple when I tell you, but many people who are kind of living on a fixed income, they have Social Security and a pension coming in. If they're married, you ask them what their income is, and they will tell you the combined income. It's just a kind of a way of thinking. There's no reason to think otherwise most of the time. But in Medicaid, you need to separate the incomes and only look at the person who's applying for benefits. For example, if the husband's going into the nursing home, you would use the husband's income only and do not consider the wife's income in determining eligibility for benefits. Okay. So what you have on your screen there is I've drawn a line. That line is the, I'm not sure if your screen is working or not. It might have gone out. I see that. Sorry, guys. Your job is to hit the button for me to keep it. Oh, now we got to go for the password. Very, very good. So, oh, very good. Yeah, we're going right on time. Excellent. Thank you, Cindy. Let me get that for me for the sake of everybody else. If the rest of you will excuse me for a second. Your job is to make sure that this computer does not go away. Okay, thanks guys. Okay, they need to be able to see what's going on the screen like the rest of you guys are. They're kind of without that extra little visual aid. All right, you see that line on your screen? What that line represents is the income cap. Thank you guys. Every big operation has got to be some small little things. Remember, this is our first time at doing this, so thanks for everybody being so patient with us. Cindy, what are you doing there?
I'm making a mess.
Thank you for helping. All right, good. Sorry, guys. All right, first time for everything. We're going to be a lot better the second time we do this, I'm sure. All right, everybody see that line? What that line is a metaphor for what the income cap is. All right. Now, that line represents $2,130 of gross income per month. Now, you are good if you're below the line. You're bad if you're above the line. If you're below the line, you're eligible for Medicaid benefits. I want to make this very simple for you to understand. If you're above the line, if you have more than $2,130, you're disqualified for Medicaid benefits. Hence the good below, bad above. What happens if somebody like this shows up in your world? Somebody that makes $2,131 of gross income per month. Is that good or bad? It's bad, isn't it? Really bad. It's really bad because that person now is disqualified by how much? $1. All right. Now, when I first started practicing elder law 23 years ago, if you came into my office and said that you were Mr. 2131, I didn't have anything to do I couldn't fix that problem. My only solution was to send you to New York. Why New York? New York doesn't have that line. They don't have an income cap in that state, but Florida does. So if you're over the line in Florida, that's bad because you're disqualified for Medicaid benefits. And that was the way it was for many years until a guy by the name of Miller showed up in the Medicaid office in Denver, Colorado. Now, Mr. Miller was applying for Medicaid benefits. And for the sake of discussion, he shows up and he's eligible under every criteria except he's Mr. 2131. He's right over the line. He has too much income to qualify. In Colorado, they're an income cap state like Florida is. And they said, I'm sorry, Mr. Miller, but you're not going to qualify. And this is somewhat hyperbole, but they gave him a map to New York and said, hey, good luck. Mr. Miller wasn't real happy about that. So he went out, hired an attorney, and this attorney put his thinking cap on and was able to see something that the rest of all of us elder law attorneys didn't see. And what he saw was that Medicaid was a combination of federal and state law. And because of that hybrid nature, it was subject to the federal Constitution. And basically the argument was made that this law was unconstitutional under federal law because it violated the United States Constitution Equal Protection Clause. It basically said that, hey, you're not being treated the same as somebody else in New York. It's a federal law. You should have some fundamental parity between the two of you. And you're being disqualified in this state, but not in New York. So, and I'm summarizing the argument here, but basically unconstitutional. So what the court said is we're not going to throw out all the Medicaid law in Colorado, but we're going to give you a workaround, Mr. Miller. We're going to create a solution that will allow you to qualify for Medicaid benefits in the state of Colorado without having to go to New York. And what they did is they created something called a Miller Trust. This Miller Trust is now known as an income trust. When I have a discussion with that with my clients or in other presentations, I like to refer to it as an excess income trust. An excess income trust means there is an excess income that has to be moved through the trust in order to get eligible for Medicaid benefits. So the solution to this problem now is not a map to New York, but is an income trust. Now, an income trust works like this. I'm going to throw up a little graphic on your screen so you can see kind of what happens. This little picture has a couple stick figures on it. The stick figure on the top is the Medicaid applicant. Into his bank account comes income every month, Social Security and a pension. He's going to go into the nursing home. He wants Medicaid to pay the bill for him. Medicaid's going to look at what his income is. If it's below the line, he's okay. He does not need an income trust. So Medicaid says, assuming all the other things are in order, we're going to pay your nursing home bill, but we want you, Mr. Applicant, to pay part of your own way. So that's that arrow that's going down into the nursing home. He has to pay his income to the nursing home every month. Okay, so you see that. Very good. If Mr. Applicant is over the cap, he's 2131 or somewhere up in that range, then he has to create an income trust and take the excess income, in this case the dollar, and pass it into the checking account owned by the trust. That will reduce his income below the cap amount and thereby allow him to qualify for Medicaid benefits. Solve the problem. Double thumbs up. We're very happy about that. But if you look at the chart, that income doesn't stay in the trust. It actually flows out of the income trust and goes into the nursing home at the end of the month. Why? Because the nursing home is entitled to all of the income of the Medicaid applicant or the Medicaid recipient. Medicaid will make up the difference. Now, it's usually entitled to all of the income, unless there's a spouse in the picture. Now, today, I have these problems every day. We had a spouse who was making about $700 a month, maybe $900 a month. And her question was, well, what happens if my husband goes into the nursing home? If I have to give up all of his income to the nursing home, how am I going to live on my $900 a month? Good question, right? Well, Medicaid understands this dilemma and actually provides a solution for us. And if you look at your chart, you'll see that there's a other little stick figure on it, and that's the spouse of the Medicaid applicant. And what happens in that situation is that that spouse is entitled to what's known as a spousal diversion or a minimum monthly maintenance income allowance. It's a way of diverting some of the income that would have gone into the nursing home, diverting it over to the spouse who's in the community still trying to make it on her income. How much you can divert to that spouse depends upon how much she makes and what her or his, because there's no bias here, whether it's husband or wife, what that spouse's shelter costs are. The more expensive it is for them to live in their home, if they have high rent, high taxes, high insurance, high mortgage, you can give them more money. If they don't have those expenses, they're going to be reduced to, not reduced, but limited to the minimum amount, which is $1,900. And then the top of that is around $2,800. So there's a range that we can raise the spouse to. It's called a minimum monthly maintenance income allowance. And that's the little spouse on the side. Anybody have any questions on the income side of things here?
Does that work if there's an adult child that has been taken care of?
Interesting. If there's an adult child, which oftentimes there is, providing care, there is no way to afford you any kind of stipend or anything for providing that care if you're doing it gratuitously. I can't do that spousal diversion to you unless you're an adult dependent child, disabled child living in the home. That's a very rare circumstances, but when that is, there is this exception. Usually it's only the spouse, but in some circumstances it can be the adult dependent child. Okay, so very good. Any other questions on the income side? Your takeaway here is that if you're over income initially in Florida, you're disqualified from Medicaid benefits. But if you have an income trust in place and funded, you can get below the cap and qualify. Now, the big problem here is getting the trust in place. Who's going to put that trust in place? Who's going to create it? Now, the law says, yeah, I can draft it. That's, yeah, I guess I can draft it, but who's going to sign it? Who's going to kind of give life to the trust by executing it? Now, the applicant can sign it, but many times the applicant may be incapacitated, right? Yeah, their brain's not able, they're not in a situation to sign that. So who else can sign it? Durable power of attorney. If it says it. Good. I'm glad you guys are paying attention. 2 thumbs up. All right. Candy for everybody after this. All right. Very good. So that's one of the points why that's such a big deal for me. Okay. All right. Let's move on. All right. We talked about the income trust. Now what we want to talk about are assets. When we talked about income, we use that metaphor of a line, right? You were either above the line or you were below the line. For discussion about assets, I kind of changed that metaphor a little bit, and instead I used the metaphor of a circle, or in this case, a target. And what that circle represents on your screen is the amount of assets that the Medicaid applicant can have and still be eligible for benefits. It's a limitation. You have to be inside of that target. Now, the size of that target, you might think, is really important to whether or not you qualify for Medicaid. I guess it's relatively important, but it's not ultimately a deal breaker, so to speak. For example, when I tell you that a single person is only allowed to have $2,000 in order to be eligible for Medicaid benefits, the size of that target seems to be pretty small. But in reality, all that $2,000 does for us is set up a math problem. We take how much assets the person has, subtract the $2,000 that they're allowed to have, and that returns the amount of assets that must be protected in order to qualify for Medicaid benefits. So don't sweat out that $2,000. My job is to make sure that you are inside the target.
And that asset does not include the house?
Does not include the house, does not include the car. Okay. So $2,000 in countable assets seems small. To get inside that target seems an impossible task. I want you to trust me on this. It is not an impossible task in any way. Okay. If you happen to be married, the size of that target expands. It's much bigger. And it expands by adding an additional $115,920 that you and your spouse can keep. As I know everybody says, well, that seems to be unfair. I don't have any comment on
So
fairness.
If you're married, you're wealthy, and if you're single, you're poor.
Well, if you're single, they're only going to let you have 2,000. If you're married, they let you keep the 2 and the 115,920 for 117,920 grand total.
Oh.
Interesting, huh? Okay, so that target gets a lot bigger. I've actually married somebody in my career in order to get them eligible for Medicaid benefits. Not me personally, I didn't marry them, but I officiated at the wedding to get them married. Okay, in order to, because as soon as they got married, their target expanded and included all of their combined assets. Now they had been living together for 30 years. It wasn't a big stretch to marry them, mind you. And I've only done that once, but it does kind of put a point on the pencil, so to speak, as to what I'm trying to tell you. The target's much bigger if you're married. Very good. Any questions on that? Okay. See that little dot? If you're inside the target, you're in good shape. If you're single and you got $2,000 or less, you're eligible for Medicaid benefits. If you're a married applicant and you have 117,920 or less and you're inside the target, you're in good shape. The problem occurs though is when you're outside of the target. And that's where I come into play and bringing my skill set to bear in order to push the dot, to push you inside of the target financially to qualify for benefits. How I do that, it depends a lot on what your particular circumstances are. I like to say that every one of my clients are unique. They share one thing in common though, and that they're all different. And because of each one of those differences, it changes what solution I'm going to use in order to help fix this problem and put them inside the target. I will, suffice it to say, do generally one of two different characteristics. I'll either reposition those assets in a way that Medicaid will not be offended by. I'll move them outside of the ownership of the applicant, or I will change their characteristics so that Medicaid is no longer counting them. So when they're no longer counted, you will then go back into the targets. It's all about moving you inside the target. That's the metaphor I want you to take away from this. Got that? Okay. Now, when it comes to assets, there are, as we mentioned, certain things called non-counted assets. Primarily in Florida, there are two big ones, two major non-counted assets. One is your home, not counted as an asset while you're alive. And if it's going to your heirs when you die, your blood relatives, it'll be protected under Florida's Constitution, and the home will go to those relatives even after death without Medicaid being able to assert a lien against the home. Also is your car. It's not counted as an asset either. Now, one car of any age, and then any other car older than 7 years is the technical rule. So you couldn't have more than one car. Funny, yesterday I was at a seminar and I was presenting, and the guy in the front row goes, "Well, that's just about every one of my cars is older than 7 years." So those cars are not counted either. Very good. Non-counted assets. All right. Now, if you guys have any questions out there that are kind of listening on the web, be sure you can type those in. I can either take them now or I'll take them at the end and kind of deal with them kind of in a discussion if you want. We'll see how many of you guys actually ask any questions. So, all right. So I see one person. Cindy, will you take a look at that for me? You can't see it? Oh, really? All right. Well, this is part of the things. I can see the question that's on there. What if the spouse has already passed away is one of the questions. If the spouse has already passed away, that changes a lot of different things. First of all, you're now going to be in the $2,000 circle as far as the target is concerned. The spouse not being in the picture is not going to change the countability of the house. We discussed that earlier. I just want to review that. It's still not going to be counted as an asset. And when you pass, if that property is going, that home is going to your blood relatives under Florida's Constitution, then that's not going to be counted as an asset either. And it's also not going to be liened as against or taken by the state at that time either. Okay.
And as a blood relative, can that also be like nieces and nephews?
Nieces and nephews, absolutely. Yep. The technical term under Florida, I call blood relatives because it's easy for you to conceptualize. The technical term is heirs. Okay. And heirs is a very broad category of people. If in any way they would take under the laws of intestacy in your situation, they can be considered your heirs. For the sake of kind of understanding it, I use blood relatives because is that somebody that's your family that it's going to? A person that's named in your will that's not an heir, like Karen, for example, in your situation, would not be protected under Florida's Constitution. Okay, so very good. All right. After the non-counted assets, let's go to the next thing, and we want to talk about gifts. Gifts. How many of you guys have made gifts in your life? Christmas is coming up. Do you guys make Christmas gifts? You ever give away anything for birthdays? Maybe, yeah. Are you charitable? Do you give something away to your church? Yeah, of course, absolutely. Any of you guys make political contributions? It's kind of, you'll see the irony in that in a second. The fact is that gifts are the surest way of disqualifying you for Medicaid benefits. Now, all the way up until now, we've been discussing about how to become eligible and qualify. What are the qualifications? Well, gifting is a way of disqualifying you for Medicaid benefits. Quite simply, Medicaid has one commandment, and that commandment is thou shalt not give your assets away to qualify for Medicaid benefits. If you break that commandment, Medicaid will disqualify you. In other words, they're saying, no, we're not going to pay anything towards a nursing home. That actually is a pretty big deal, okay? So you do not want to violate this rule. So no gifts, okay? That's the prohibition. Now, when I say no gifts, does that mean that all you guys here who look like you're relatively healthy can't give away anything for Christmas? Not necessarily, okay? But if your spouses are dealing with Alzheimer's disease and you guys are on a path to the nursing home, and that nursing home is coming up and you can see it coming over the horizon, and it's a reality in your world, not just a possibility, not even a probability, but a very good likelihood of being in your future, I would strongly discourage you from making gifts at this point in time. Medicaid's new rules that they've implemented in 2007 under President Bush, I want to give credit here. President Bush and Congress at that point in time, at the behest of the long-term care insurance lobby, again, no big deal, it's just the way it is, everybody should get credit for what they do, pushed forward legislation that dramatically curtailed the access to Medicaid eligibility. And they did that by basically taking gifts and making it a total disqualifying act. Prior to this, if you gave away a small amount of money, and even if you gave away up to $5,000 in any given month, Medicaid basically said, you know, we're not going to sweat that small stuff out. We understand you make gifts in the normal course of your life. We know that those small gifts weren't designed to qualify you for Medicaid benefits. It was just living your normal life. Well, and then in 2007, what this new law said, basically, we're doing away with any safe harbor. There is now no longer any safe amount of gift to make. Every gift that you make is a disqualifying act, regardless of its value. So what they do is they are going to look back for 60 months to see how many gifts that you made, and they're going to add all those gifts into what I call a super transfer. Now, under the rules, they're supposed to take that amount of money, divide it by a certain amount to get how many months you're disqualified for Medicaid benefits. Basically, for about every $250 of gifts that you make for every $250 of gifts, it'll translate into about 1 day of disqualification for Medicaid benefits. Now, that's the rule. The reality that we see is that Medicaid and the Department of Children and Families in the state of Florida is not applying a fine-tooth comb in this situation. So it puts me in a very difficult position, actually, as a lawyer to advise you on this, because I know what the law says. I know what should be done. Everybody in this room, everybody listening tonight should be disqualified for Medicaid benefits because you made these gifts. Even if it's for a couple of days or weeks or months, you still should be disqualified. But the way the system is set up right now, it's not really designed with enough resolution to pick out those smaller gifts that you make. And there are arguments that can be made that those gifts were not made with the intent of qualifying for Medicaid benefits. So what the reality is now is that Medicaid is not picking out those small gifts and not disqualifying you, even though they could. But I cannot in any way tell you how big of a gift is okay, or how long ago that they're gonna ignore it. Technically, they're supposed to look back 60 months and add up every single gift: church tithe, birthday present, Christmas present, charitable contribution, political contribution. If you paid off your son's mortgage, if you bought him a new car, if you gave him a wedding present, a grandson for a christening, I don't know what you'd give money away for, but technically they're supposed to add all of that up.
How are they going to
I love that question. The question is, how are they going to know? Okay. Uh, well, and we had another question from the web actually, which is what if you cash a check and you give the cash away? How are they going to know? Right? Same question that you asked. Right? Very common. Very good question. And the answer to that is that they're going to ask you. When it comes time to apply for Medicaid benefits, Medicaid is going to ask you, have you made any of these gifts? And I call this the kind of the Dirty Harry scenario. Do you feel lucky? Okay. Now that's kind of a joke. But the bottom line is the moral and ethical and the legal side of things is that, do you feel lucky? Well, let's ignore that. Let's not play that game. They're going to ask you, if you fail to disclose the gift, that's fraud and can be considered a felony. That's illegal.
Yeah, but then you'll end up in prison, so you get long-term care.
Correct. Yeah, I used to have a graphic I used to throw up. And it said federal penitentiary and nursing home over the gate for that same reason. Yeah, if you give it away, you get thrown in prison. Then what do you need nursing home for? Right, exactly.
Most people don't remember what they gave.
Well, this is the joke. Okay, now I know you guys have all dealt with Alzheimer's, but this is probably the one case where Alzheimer's can actually be your friend. Okay, because you forget that you made the gift. Okay, again, that you made the gift. What was that? Yeah, is it your hearing or your brain? I could never get it. So, just kidding. All right. I love this. I have. It's so funny. We have these. It's funny how we all think the same, even though we're not here. Some of the questions from a couple of questions from the web just came over. It says, "Well, what happens if you have Alzheimer's?" So you guys are all thinking along the same way. I like that. That's great. All right, so we're kind of winding down here towards the end of the presentation. We've talked a little bit about looking back this 60-month period in time. Are there any other questions before I kind of wrap this up? Because I have one more thing I want to talk to you about. Yes.
I have one question. What if the person is in the nursing home, but they get better?
Uh-huh.
Do they do a reevaluation on that person? Are they allowed to still remain?
Well, remember there are three. The question is, if the person gets better when they're in the nursing home and on Medicaid, what happens in that circumstance? Well, remember there's three things that you have to look at. You have to look at how sick the person is, how old they are, and what their financial situation is. So that first criteria is how sick they are. If they are no longer sick enough to be in the nursing home, they no longer meet Medicaid's criteria to be eligible for benefits. So, I mean, if you got better, I got good news and bad news. You know, the good news is you get to go home. The bad news is you don't get any Medicaid, or vice versa. Do you see? Okay. So yes, you know, and in reality, we unfortunately rarely see that particular situation. But if somebody did get better, then they would lose their benefits, but they would also get to go home.
What if they're like 95 years old? And they have really nobody to take care of them at home? Would they kick them out? Or they wouldn't kick them out. So would they kick them out in a situation? Let's say they're 95, for example, just in case for everybody to hear it. I'm not sure if you guys can hear that out or on the web. But would they kick them out if they got better? You know, the situation is at that point in time, they'd lose their eligibility for Medicaid benefits if they did not meet the criteria to be in the nursing home any longer. That's the technical answer. If they would go into private pay and they'd have to pay $10,500 a month. If they couldn't pay that private pay amount, then they can be discharged from this facility. There are some ways of getting them out of the nursing home. Thank goodness that dilemma we don't see very often. Okay, it could create a problem for us, but I'm sure there'd be something that we'd want to be able to fix that. And I guess if you think about it, that's really a good reason to actually preserve your assets just in case you get better. Right? Because if you get better, you may need to go to the assisted living facility where there's not a lot of good coverage for. And I love this. I love you guys out there. Does Medicare, question from the web, just make it, because it's right on point. I want to read this out to you. Does Medicaid cover any Alzheimer's home care, or let me expand that, care in an assisted living facility? At the present, you're going to ask that, right? See, everybody thinks the same. I love that. The answer here is at the present time, we don't know. We're in a transition zone right now. I know, isn't that? Well, sometimes you just don't know.
The reason why we don't know is Governor Scott is currently rolling out a new way of delivering Medicaid to Floridians. And this new managed healthcare model is supposed to bring on and bring to bear some coverage for the assisted living facility. We haven't seen the actual rules and how they're going to implement it yet. And I think they don't really know themselves, to be honest with you. But we don't know yet. But we do know that coming the first of the year, we should see this new program being rolled out. And then there may be some coverage for either home care or for care in the assisted living facility. Exactly how much, I don't know. Okay, so stay tuned on that. For those of you guys that are out there on the web, you may have to come and up here and see this again come the first of the year to get those that new information. So I wanted to end on this particular question. A lot of times clients and people that are attending my seminars will get real tied up around the how do you qualify question. And that question really, in my world, is not that interesting. It's from my world and in what I do, it's kind of mechanics almost. Just put this peg here, move this lever that way, and we'll qualify you for Medicaid benefits. That's kind of a mechanical answer. The more interesting question is, when do you do this kind of planning? When do you take action in order to qualify for Medicaid benefits? And to answer that question, I talk about three different types or ways of thinking, three different types of people. The first is what I call planners. Planners are people that like to have an answer for every possible contingency out there. They go out, they'll take effort, they'll spend money, they'll take time to get a plan in place for these possible contingencies. As some of you may snicker a little bit, because as you know, the human condition does not give rise to a lot of planners. Most of us are procrastinators, right? So that gives rise to the other category, which are what I call my uh-oh clients, or the uh-ohs. And the reason why I call them uh-ohs is because they haven't done anything about this problem. They've ignored it. They've seen the train coming and they just close their eyes until it runs over them. And then they do something about the problem when they're in the nursing home. And the reason why I call them uh-ohs is because they open that bill from the nursing home, they scroll down, they see $10,500 for this month and pre-billing you $10,500 for next month, $21,000. At about that point in time, they go, uh-oh. Okay, hence the name uh-ohs. Where you need to be very careful, I think the sweet spot here, obviously you may not be a planner, you probably don't want to be an uh-oh, but you may not be able to help that situation. The sweet spot here is what I call a writing on the wall client. And that's that person who has some indication that this problem's coming at them. A diagnosis of Alzheimer's, for example, is an awful big sign hanging on the wall that you should do something about this problem. If you have a diagnosis of some other progressive degenerative disease, you're starting to experience a lot of mini strokes, something along those lines. Now we want to do something about this under those circumstances and take action now as opposed to later. Okay, we got a lot more that we can do, a lot more opportunities, and also the benefit that you get from taking action is much better because now that problem's really solved and you can take it off of your plate of things to think about and worry about. You got enough things on your plate, especially if you're dealing with Alzheimer's, to deal with. You don't need to have this fear of financial ruin looming out there either. So let us get at it. Let us show you how to fix this problem. Get it off of your plate if you have that writing on the wall. So you're going to fall into one of those categories. If you don't have writing on the wall right now, you're 70 years old, you just got back from Mount Kilimanjaro, your blood pressure is right in the sweet spot, your LDLs, your HDLs, and all your other L's are all perfect, you probably don't need to do this right now. Although you need to have that power of attorney in place just in case. Okay? Any other last questions before we close with tonight?
Just on assets and income, where does life insurance policy fall?
Great. We talk about assets. Where do life insurance policies fall? And the answer is it depends on what kind of policy you're talking about. If it's a term life insurance policy, that's not going to be counted as an asset whatsoever. Don't worry about the face value, how much it pays out when you die. I don't care if it's $1 million policy. If it's a term life insurance policy, it has zero value. Okay. What we're concerned with are those life insurance policies that have cash value, often referred to as whole life. These policies will have some sort of cash value, which is what they'll give you if you surrender the policy now before you die. So you can go to your insurance company and say, okay, well, tell me what the cash value of this policy is, It's that number that's counted as an asset. You understand? Okay, so good question. Anything else? You guys have been really good tonight. Excellent. Any other questions out there on the web? Anybody that's asking? I'm going to let everybody go here in just 1 second. All right, fantastic. I just want to say thank you for everybody. This was a lot of fun. I've never done this before. I know we had a little bit of hiccups. I know we had some issues, but overall, I think it went okay. So, all right, and we'll try again next month and see how that is. For those of you guys who are out there on the web, this is going to be recorded and uploaded to our website at virtuallawoffice.com. So if you want to get a recording of this, or if you want to watch this again or share it with some other people, you can do that. Also, take a look at our website. There's a lot of great information on there. My book is on the website that you can download and read all about this issue. There's some good videos that we host there that I've done on issues related to elder law, including planning for long-term care. You can watch those videos. A lot of interesting stuff there as well. And there's also a schedule of when we're going to be appearing live here in Pinellas County, Pasco County, and Hillsborough County, talking about this live. I encourage you to come to one of those presentations as well. And again, just thank you very much for listening, guys. And I guess that'll basically conclude our presentation tonight. Thank you very much. Yay.